Tonight we're talking about drunk driving. While DWI arrests are becoming less common, the legal, social, and financial ramifications of driving a vehicle while impaired remain significant. Welcome to Lawyers on the Line. I'm Sean Quinn, a partner at Falsani, Balmer, Peterson Quinn, and this evening's moderator. I'm pleased to welcome our panelists, Gerry Wallace of the Wallace Law Firm, Chris Pinkert, Assistant St. Louis County Attorney, and Brian Malvick of the Malvick Law Office and an Assistant Public Defender. We're ready for your questions. Call the numbers at the bottom of the screen, 218-788-2844, or toll free at 1-877-307-8762. And now we'll go to the topic. Gentlemen, this is what happens. Someone's drinking, driving, they get pulled over by the police. Next thing you know, they're handed a telephone. You can go ahead and call a lawyer. Gerry, you get that call. What are you going to tell this person?
First thing I'd probably ask him is, where are you? And were you driving? Have you been asked to take a test? What kind of test have you been asked to take? One thing most people at this point should expect is if they're asked to provide a urine sample or a blood sample, they should ask and receive a search warrant signed by a judge. And if not, then they should refuse that type of test and ask for a breath test instead.
Okay. Fair?
Yeah. When you're arrested for a DWI, when you're brought to the police station or the law enforcement center, you're given the opportunity, when you're sitting there before the officer asks you to provide a chemical test, you're given the opportunity to call an attorney. So you get some time to do that, and if I get that call, generally the best piece of advice is to cooperate and provide that test, because if you don't provide the test, usually you're going to get a more significant or serious charge if you don't do that.
Okay. Well, Chris, what are those significant charges for, someone says, no, I'm not going to blow in the tube, I'm not going to give you a blood or urine sample?
Sure, yeah. Minnesota law makes refusal to take a chemical test when an officer has probable cause to believe that you've been driving under the influence a separate crime. And so if you don't take the test that the officer is demanding that you take, you're going to be looking at a minimum, a gross misdemeanor charge. If you take
the refusal charge.
The refusal charge would be a gross misdemeanor at a minimum. If you take the test and you're below a 0.16 breath alcohol or blood alcohol concentration, you'd be looking at a misdemeanor. So, depending on your circumstances, usually the best option is to take the test, and that's what I think the advice of most defense attorneys is take the test.
That's correct. That's usually my advice, is to take the test. I can't think of an instance where I've advised a client not to take a test. I think the one time where it may make some sense is if you think you would have been below 0.08 and you would be possibly in a situation where there's a really good argument for you not to have been in physical control or have been operating the motor vehicle in some fashion, but generally 99.9% of the time, the best advice is to take the test because, like you said, Chris, it's something that can be used to enhance a DWI or a test, or the refusal charge is an enhanceable factor. So if you end up in a second degree area, you're facing a vehicle forfeiture, where if you've taken the test, you're simply facing a license revocation. And so when you talk about legal social ramifications, that's one of those things where, taking the test is likely to save you some headache in the future.
And frankly, I think Chris could attest to this. Usually if you refuse to test, it makes the state's case a lot easier in trying to prosecute you, because all the state...
Well, why is that? I mean, the state doesn't have the evidence of the blood alcohol test.
For the state to prove you guilty of refusing to take a chemical test, they just have to show that the officer had probable cause to arrest you.
For the refusal. But what about the underlying charge? The underlying, you were driving drunk.
That, they can proceed on that based upon your driving conduct, your behavior after or during the arrest.
Slurring, all that kind of thing?
Yeah. If you take field sobriety tests, if you don't do well on those, if you give a initial, what's called a PBT, a preliminary breath test, which is a roadside handheld test, if you take that test, they can use that to try to prosecute you as well, potentially on a refusal case.
Okay. Are field sobriety tests mandatory?
No, they're not mandatory, and I guess the two main types of field sobriety tests are usually an officer will ask you to get out of the car, and they'll have you perform maybe a one-legged stand test, a heel-to-toe walk-the-line test, and an eye test, a HGN, horizontal gaze nystagmus test, and they'll try to use that to try to prosecute you. Also give you a preliminary breath test. If you refuse those, you can't be charged for that, but they can use that to arrest you.
Okay. All right, so Chris, Gerry's kind of alluded to some of the consequences. Let's kind of go through them. There's the drunk driving charge. There's the refusal to provide the blood or urine charge.
Right.
What are the potential legal criminal consequences? And I understand there's also potentially civil consequences as well. So why don't you try to go through those?
Well, from the criminal perspective, or from the criminal side of things, DWIs can be charged anywhere from a misdemeanor to a felony level crime. Typically, your first DWI offense, if your alcohol concentration is below a 0.16, you're going to get charged with a misdemeanor level DWI. A misdemeanor offense carries with it a maximum sentence of 90 days or a $1,000 fine. Your second DWI should be a gross misdemeanor offense if it happens within 10 years of the first one. Your third also is likely in 10 years is also going to be a gross misdemeanor offense. But if you get to 4 within 10 years, you're looking at a felony, and you're looking at significant mandatory jail time and facing prison. There's a variety of consequences criminally that come with DWIs that range from misdemeanor level all the way up to felony level, depending on what your record is like.
Okay. Well, then what about the civil consequences of it?
And you can get the civil consequences without ever being charged with a DWI, especially if it's your first DWI. A lot of times you won't be charged until maybe a month to even as long as 3 months until after the alleged offense took place. But civilly, usually if you provide a breath test and if it's over a 0.08, the police officer will give you a notice that you now have a temporary driver's license for the next 7 days. And then after that, if it's your first offense and you're under a 0.16, your license is going to be revoked for 90 days. There's things you can do to challenge that or to get limited driving privileges, but it can happen without ever going to court and appearing in front of a judge.
And jumping back to the refusal issue for a second, is if it's a first offense refusal, you're automatically charged with the gross misdemeanor, which is 365 days in jail possibly instead of 90. Also, your revocation period goes from 90 days to, I believe, 1 year. So generally that's why the defense attorney's advice is to take the test, because the refusal is not only easier to make, as Brian said, but it also carries with it higher consequences.
Because Brian, he didn't take the test.
Yeah.
Easy conviction.
Lose your license for a year, and the only time you can get it back in that year is if you get the ignition interlock installed in your car, and then that even has some limited driving privileges that go with that as well.
All right, and aren't there hefty fines with that as well, as far as having those limited licenses and those locks and so forth?
That's true. You have to pay a reinstatement fee when you lose the license. You have to pay for the worker's permit privilege. You have to pay a monthly fee for the interlock as well as the initial installation. Obviously, your insurance is going to go up. So, and the refusal just lengthens that, doing a refusal instead of, taking the test just lengthens that period of time and increases that expense.
Okay. Well, we already received some calls from viewers. One viewer wants to know, how accurate are the over-the-counter breathalyzers? Apparently you can buy those, so that you can breathe into it and before you even get in your car when you're leaving the bar.
I guess my comment on that would be I wouldn't advise relying on one of those in making a decision to drive after you've been drinking. I come from a chemistry background, and I can tell you that there are so many variables that come into play with the accuracy of those tests. The PBT machines, the personal breathalyzer tests that the officers use, as well as the Data Master test, that's the formal breath testing machine back at the station, they're calibrated every single day or every single test. The opportunity for an over-the-counter breathalyzer to become contaminated and have the alcohol build up or not read right is significant. So I wouldn't rely on it.
Okay, good advice. All right, Brian, a question. The 18-year-old daughter has a driving permit, not a driving license. Can the dad, who has had too much to drink, have her drive him home? He's impaired. She's got a permit.
Yes. Off the top of my head, I'm not 100% sure, but I would imagine that would not be okay, and there would be potentially, I think, if you're supervising your child or someone else that just has an instructional permit or driver's permit, that the person instructing them needs to be of sound mind and not inebriated in any way. So I guess I'm not 100% sure, but I don't think that'd be a good idea. Better to
There's
err
a
on-
curfew limitation on limited licenses too, I believe, these days. Not when I took a driver's license test and had a learner's permit, but now I think there's a curfew for drivers of certain ages, and so that's something to consider in that situation as well. But I agree with Brian. I think you have to be not impaired to supervise.
That makes sense. Another viewer has a question. When police bring the suspected drunk driver into the station, are the investigations, the interrogations, are they videotaped?
It depends. It depends on which agency you're brought to, or if you're brought to the jail. Most of the intoxilizer room or the testing rooms are equipped with video recording capabilities. Not all of them. Obviously, I think that the trend is going towards everything being recorded, so I suspect that soon they all will be.
I think generally speaking, it falls under scales, so I believe it should be recorded in some fashion.
Most of them are, and then on top of that, a lot of the police cars have dash cams that record the stop, and then a lot of at least all the Duluth police officers wear body cams.
So they can record the field sobriety test as well.
And a lot of times, yes, and then even the back seat of the police car is either video recorded or audio recorded in some ways a lot of the time too.
Okay. Viewer has a very basic question. Is there a difference between a DUI and a DWI?
No, there isn't. I mean, different states call DWIs different. I think in Minnesota we call them DWIs, driving while impaired. Other states call them DUIs, driving while under the influence. I think Wisconsin is OWI, and there's other terms. So it's the same thing. It doesn't make a difference.
Different words for the same thing.
Yeah.
Okay. We talked a little bit about this already, Gerry. How does somebody get their license back now that they've had it suspended? And maybe it depends on how badly the license removal has been. I don't know.
It depends on a couple of different things. The level of charge that you were convicted of, or that a magistrate, judge, or referee found probable cause to support for the revocation. So, simply put, if you were arrested on suspicion of DWI, you were served with a ticket saying your license was revoked based on suspicion of certain type of DUI. That's going to affect potentially how long your license is suspended for. But what we were talking about a little bit before is the other ways you can go about handling that. One of them, is getting an ignition interlock device. Another is getting a work permit. No matter what, though, you have to pay a reinstatement fee, and you have to make sure that any court fines and fees you have are paid, or they can continue to hold your license as basically revoked, and then you're not able to drive.
What if you have court fines from something completely unrelated?
It is possible that your license is revoked in that situation. That would be something you would have to check with the DMV on.
If you want to fight your license revocation, I think it's 60 days
That's
from
correct.
the date of the offense. You need to file a petition for a judicial review, and you need to serve the Attorney General's office. And again, all these proceedings can take place without ever being criminally charged, and it's a pretty difficult thing to do on your own.
Okay. Can you lose your car too, Chris?
Yeah, absolutely. In Minnesota, depending on the circumstance, if you're arrested and convicted of a DWI, the state can take your car. There are a few different ways that can happen. One is if you're charged with a second degree or a first degree DWI and later convicted of that offense. The first degree is the felony level. The second degree involves a couple aggravating factors, and we can talk about that in more detail if you want, but basically it's just a more serious DWI, meaning you have priors or there are aggravating circumstances such as a high blood alcohol concentration, that sort of a thing. The other way that it can happen is if you are currently on a limited license that is subject to a no alcohol or drugs restriction on it. That means it's what's commonly called a B card. If you get a DWI while you have a B card, the state also takes your car. So there's a number of ways that your vehicle can be taken in the DWI context.
What if I'm driving my parents' car, or my siblings' car, or my friend's car, and I'm drinking, and I've got the B card? Did I lose their car?
Then it'll probably be initially forfeited, depending upon the level of charge. But then your parents or the registered owner could then make an innocent owner claim or an innocent owner defense to try to get the vehicle back. And if they didn't have any, if you were just borrowing the car for the night, and if they didn't know what you were up to, then I think they'd have a pretty good chance of getting the vehicle back. But
And it follows the same procedure as if you had your license revoked. So you'd have to do it, I believe, within 60 days. And you'd have to serve the Attorney General's office. You'd have to, well, excuse me, not the Attorney General's office. You'd have to serve the impounding authority and their attorney. So if you're in, say, Carleton County, you have to make sure, if it's the Cloquet Police Department that sees the vehicle instead of the Carleton County Sheriff's Department, you have to make sure you're serving the right prosecuting authority.
A lot of hoops to jump through.
Right.
Okay. All right. So, Chris, can you get a DWI without even having a drop to drink?
Sure. Yeah, there are a number of ways that you can get charged with a DWI. In addition to alcohol, if you're under the influence of controlled substances or hazardous substances, you can get a DWI, marijuana, prescription pills. All of those things that impact your ability to safely operate a motor vehicle can get you charged with a DWI.
even if you have a prescription for it, if you can make, there's an affirmative defense you can file if you had a prescription for the drug, but you can still be charged with DWI. I know there was a lot of talk with, I think it was Tiger Woods a few months ago, got a DWI and he didn't have alcohol in his system, but he had several other substances, so you can still be prosecuted for it.
Well, I recall a very horrible incident, 10 years ago or so, where a gentleman was taking, I think, a sleeping pill.
I think it was Ambien.
Yeah, and he fell asleep at the wheel and ended up hurting or even killing some other people. And I think he was charged with DWI just for that. So same kind of thing.
Yep.
Okay. All right, what about not a car, or say not a pickup truck? I mean, what kind of vehicles are we talking about for DWI, Gerry?
Well, we were debating this a little bit before the program, and we've kind of reached the consensus that anything that's motorized, meaning not operated by your own power, is likely something where you could be charged with a DWI. So we're talking anything from, ski-doos and boats to, I think we were joking around thinking probably a Segway. You could probably get a DWI on a Segway. But if you had for instance, a bicycle, I don't think you could get charged with a DWI on a bicycle, but I still wouldn't recommend operating a bicycle drunk.
Okay. There was a case a few years ago where a guy put a battery or something on I think it was a lawnmower motor on his Lazy Boy.
Yep. There was a Proctor, I think it was a Proctor case where a guy was arrested for a DWI on a motorized Lazy Boy. I think that's right.
Okay, but the most common thing, boats, snowmobiles, things like that?
Yep.
Okay. Okay. What about the circumstance where I'm drunk, I'm cold because it's winter, it's Minnesota, I get in my car, I close the door, but I'm not driving, and I just fall asleep in my car? Is that drunk driving?
Yeah, unfortunately that happens quite a bit, and what the law says, if you're in physical control of the vehicle. So if you're in the back seat, even sleeping, and you have the keys on you or the keys are somewhere in the vehicle, you're deemed to be in physical control of the car, so you can still be charged with DWI. You see it happen a lot with folks who are leaving a bar and maybe it's winter time and they'll turn the keys on in the ignition to warm up the car, and they're deemed in physical control, so they can be convicted for that.
Okay. what about the circumstance of, well, geez, I'm not going to drive it, but I'm cold. I'm just going to throw the cars in the back seat. Is that still physical control?
If you throw the keys in the back seat, you still have easy access to them. And the idea behind the physical control law is you don't want people waking up in a stupor and then deciding to go. So just because you're not currently driving your vehicle doesn't mean that in 30 seconds you're still going to be asleep not driving your vehicle. So that is why the physical control laws are in place.
Okay. Gerry, what about passengers? Can passengers get charged with DWI?
Well, maybe. It's always a good lawyer answer.
That is a good lawyer answer.
I guess what I would say is, if it's a situation where two people are drunk and the person who's initially driving puts the vehicle, say, in a ditch, and the other person, the passenger, says, well, hold on, I feel a little bit better. Let me take a crack at backing it out, and up shows law enforcement. I think in a situation like that, it's certainly possible that both people could be charged with DWI, but if you're just strictly a passenger in the vehicle, likely not.
Okay. All right. Same kind of question from thinks it's already been answered, but from a viewer. Sitting in the car having a cigarette. Keys are in the bar. Car's running though. Turned on the car, maybe used the electric start to keep it warm. Can the cop come up and charge you with DWI there? The car's running, but the keys are somewhere else. Chris, you're the prosecutor.
Tell you what, that's a circumstance I haven't run into yet. It's an interesting question, and it would really hinge on whether, without the keys, that vehicle could be moved. So there'd have to be some sort of an analysis done as to whether the person who was sitting in the car without the keys could get that car to move.
Do you guys agree?
I'd take it to trial.
Take it to trial?
I'd take it to trial. I think it's an interesting question because if you can put the car, if you have the keys in the bar, and so part of the circumstance you're dealing with is the question, the ever-present question of the intent to drive, and it's part of the circumstantial analysis in a case like that. And if you can put the car in gear and go home, I think Chris could probably get the conviction. Sure. But if you can't move the vehicle, it's really a very good question. I think it's probably it's a really good question.
Best bet: have the smoke outside and go back in the bar.
Yeah, that's your best bet.
Does the test, the blood alcohol test, or the blood test, the urine test, does that have to be administered within a certain amount of time from the time when the police first pick you up?
Generally, it needs to be done within 2 hours of your driving conduct or when you drove the motor vehicle. If it's done outside of that time period, then I think, was it, Chris, extrapolation, I think?
It's called the retrograde extrapolation. Basically what the statute requires is that the state prove that within 2 hours of operating the motor vehicle, you had an alcohol concentration that was greater than 0.08. Scientists, and I've had this done in a few cases, down at the BCA, based on the information that they're presented with from the test result that was outside of that window, things such as how much food did that person have to eat and when, and a variety of physiological factors, they can calculate where your alcohol concentration would have been within that 2-hour window based on a test that was outside of it.
And if they do it within the 2 hours, they don't need to do any of that retrograde extrapolation. But if it's done outside of it, and usually you see that happen sometimes in a situation where someone is arrested in a real rural area, or there's some sort of maybe an emergency situation that happened where someone needed to go to the hospital or whatnot.
Okay. All right. What happens if a Gerry person gets pulled over, they give them the PBT, the preliminary test, maybe some field sobriety tests, they pass it, but the cop still is suspicious? Can the cop take him into the station and force the blood or urine test?
The officer better get a search warrant. I'd be very curious about what they state in the search warrant if the person passed the field sobriety test and passed the preliminary breath test. We were talking about before, there's different ways to be intoxicated. And
so it could be drugs or something
yeah,
like that.
It could be a controlled substance, a narcotic. And if it were, there would certainly be indicia of impairment, and I just don't think you'd be passing a field sobriety test if you were under the influence of a different substance.
Okay. We only got about a minute left, so real quick, Chris, can the state force somebody to go into alcohol treatment or drug treatment after a DWI?
Yeah, that's pretty typical that as part of a DWI case, a chemical dependency assessment is ordered, and as part of probation, you're ordered to comply with the recommendations.
Okay, now there's a cost to that, is there not?
Typically, yeah.
Okay, what if the person can't afford it, right?
A lot of times, if you're on probation, or the county will hopefully work with folks to get them connected or hooked up with some form of insurance. I know there's a chemical dependency fee, usually of $30 that the court imposes if the court does the chemical use assessment.
Okay, Gerry, any thoughts on that?
I just wanted to say real quickly on felony DWIs, one thing is that if you go to prison, you are subject to conditional release, which is possibly more prison time after a felony DWI. So it makes a lot of sense if you're a person who is drinking and driving to never get a felony DUI.
There you go. Well, that's all the time we have. Please join us next week when we answer your questions about automobile injuries. I want to thank our panelists this evening and thank you for watching. I'm Sean Quinn. Good night.